Legally Naya. Legally Naya. Hello everybody, welcome to today's video. Welcome to another banger and welcome to part 3 of my week in the life of intellectual property legal intern. I feel like every video gave a different taste. Like my first one was more trademark law and then the process. My second one was mainly about copyright law, and now this one is going to be a mixture of copyright, trademark, and really patent. So yes sir. Right now what we have to do for this week is I have a patent blog to create. I also need to respond to my client about copyright research because I went back and I found him an answer, and I sent my response of what I would say to the attorney so that she could send it to him, but she actually told me to send it to him. So now I just have to tweak a couple things, and yeah, so that's what I'll be doing this week. She let me take the lead in the client meeting. Whenever he had a confusion or a question, she let me answer it. She directed him to me, and that was actually pretty fun because it let me know that I knew my research, I knew that I found the correct answer, and I knew how to explain it to a client. And that was really fun because I'm 24 and my client was probably older than me, clearly, but it's just so fun to know that even though I'm young, people respect me as a future attorney. And yeah, it's all about having confidence and just knowing what you're talking about, being thorough in your research, and making sure that you really know what you're talking about before you speak to your client. Before I go into a client meeting, I literally sit there, pull up their names, pull up their case, refresh, and make sure I know what's going on. So we're gonna directly send him a response right now, and we're gonna work on our patent blog. I've already done a lot of research for this. Sorry guys, you are catching me during the research to writing stage, and right now I will be finishing and editing and fine-tuning my patent blog. And my patent blog is about continuation and part applications. And let me explain to you what a patent is really quickly first. There's 3 different types of patents. There are design patents, plant patents, and utility patents. And patents are created and were made to encourage and support technological growth and advancement by allowing inventors to get legal benefits from their creation. So copyright protects creative works, trademark protects branding and business identity, like being the only person to sell that good or service with that name, and patents protect an invention. That's the main difference, but all of that is considered intellectual property. So now let me tell you guys what I'm working on in my blog post. And my blog post is specifically about a continuation in part application, and this goes with the patent process. And basically, continuation in part is when you realize you want to add something to your invention that was not previously disclosed. So you file a continuation in part, which acknowledges the old subject matter but also adds new subject matter. The good thing is your old subject matter priority date will still be from the previous application, but the new subject matter's date will come from the continuation in part. In patent law, dates matter because the first to file is the first to be acknowledged for the rights, so that's why you want to keep the old date for the old subject matter. But through a continuation part, you can add new subject matter if you discovered something while you already filed a patent. Now the catch is, for a non-provisional patent, which is your standard patent application, you have to do this before your patent is approved. So once it's approved, you can no longer add new subject matter through a continuation in part. And then if you've done a provisional patent, which is kind of like a pre-application before you submit your non-provisional patent, just so you can get a first to file date, because like I said, whoever's first to file gets more rights. So sometimes people just file and do a provisional patent to make sure that they are at least acknowledged as the first person in time. But if your priority date is a provisional patent, you have 12 months from that date to make sure that you file a continuation in part unless your patent gets approved. So it's deadlines and timing when it comes to wanting to add new subject matter, unless you'll be out of time and literally you will have to file a new application to where your old patent can now be used against you for something that already exists when it comes to prior art and a previous invention. Because remember, you have to make sure when you create something that there's nothing else like it, or else your patent won't get granted. So it will be on your attorney to distinguish your new art from your prior art if you have to file a whole new application, which is possible with a right mindset, but just a little bit harder for your attorney. And because you have to think, it is the U.S. Patent and Trademark Office examiner who has to think, is this too similar to this patent, or is this a whole new thing? So it's not on you to get something approved, but you do your very best to show that it's not the same as the attorney. So yeah, that's what I'm about to write about for my blog, just to keep patent holders updated, because at the firm I work at, they make sure that we educate clients, and I really like that because sometimes clients don't know what's going on and you have to tell them why things are important, and just things to keep the active learner engaged and knowing what's going on. Especially if you take your business seriously, you want to know what you should know. So that's very good about the firm. So I'm about to go write that post, and later we have a meeting today, but we're going to talk about that later. So come with me to continue editing and finishing our blog post and to send that email to the client. And like I always say, don't forget to come to me in the future.
I do that 3-4 times again, I testify for you. I'm so that like you, that bitch, I do it.
Hello everyone, update. So I've really been working hard and doing my blog. I feel like I've gotten down to like my final version, which is really helpful. I used to be, when I was a 1L in law school, I literally just used to write one draft and submit it. And then I realized that's where I was going wrong. When you actually write legal documents, legal things, you need to sit with your work, look at it, revise it, edit it, and really just look at it many times before I really send something to the attorneys. I do multiple passes, multiple rewordings, multiple checking my grammar, just really making sure I'm giving as close to a final draft as possible. And yeah, that's what I've done, that's what I'm doing, and that's what I've really finished. And I sent the email to the client. Basically, I wasn't able to do it through the system because I'm technically an independent contractor right now. I had to tell it to the supervising attorney, Attorney Randy, and she sent it to them, but said from Naya, and I was in the email, so that is officially done too. Right now it's like 1:15. I have a meeting at 2 p.m. with Pranita where we will be doing SOPs, which is standard operation agreements. And basically this is the behind the scenes for the firm. Attorney Randy wanted to do something that lasts an impact for years and generations and interns and attorneys to come. So I've done that for trademark searches. I provided a specific example from a client and another trademark search. And I've also done how to prep for a trademark application. And now me and Pranita are going to go over it and add things, take away. I had to provide definitions for the next person, like likelihood of confusion, generic trademark name, descriptive names, office actions. You had to leave definitions in there. You had to show the step-by-steps. You had to tell the purpose and the purpose of why you have to do this. So it's actually good for the next person. That was also double learning for me. You know, going through something and then having to write it down on paper lets me know that I really know what I'm talking about. Also, I have to create Loom videos, and outside of just the SOP documents of somebody looking at it and writing, I create a video, like a 5-minute video going through it and basically showing them the steps. So not only do they have procedures in paper, but also video. And it's crazy because I'm like, dang, that would have helped me a lot if I had that when I was coming here. But I'm glad to also pay it forward and give it to the next person. And it's actually kind of cool to know that, like, you know, if you ever work at where I work in the future, I started some of those templates. As a legal intern, as a law student, as somebody working in the firm, even attorneys, when they join a firm, sometimes attorneys in the firm already have tons of templates to go through to use, to tweak and edit. But I am one of the original template creators. And I remember I used to be in like the disability clinic, and I used to be like, whoever made this template, bless you. And now that's me. So that's one of the cool things I learned at this firm was, you know, doing the operation side, doing their social media side, and also doing the legal intern side. So I learned a lot from a business perspective, but also as a future attorney perspective and, you know, a content creator. But we're going to get ready for that meeting. I shared those documents with Pranita. I made a Google Drive. That way we can both edit or work on it while we go through a meeting together and be efficient, because I like to be efficient. So that's what we're about to do. We're about to do the operation side now, and then after I might just knock out the Loom videos today, because after today I'm going to Orlando. So I got a lot to finish, and I finished what I really needed to do. I emailed the client basically, even though Attorney Randy did that for me. I fixed up the email as if I was speaking to him directly. She sent it off. I finished my blog. I went through through my SOPs this morning and tweaked them and tweaked all 3 and made sure they were more updated. And now I'm going to go over it with Pranita, and we're going to submit all 3 today. The loom videos, I don't know if I'll be able to do today or maybe next week. And we have a lot more to go, but I'm going to pick that up and tell you guys when we get there. So stay tuned for more of the video. See you guys soon, my loves. Hey, wait, while you're here, you might as well just go ahead and like the video, okay? And drop in the comments if these videos help you, whether you're a legal intern, a law student, somebody interested in IP, or somebody who wants to be a possible future client one day from the client perspective. That lets me know to keep doing these kind of vlogs. See you guys soon. Sorry, I had to get my food.
Like damn, she in her mood. 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 She lit, get money too. Like damn, she in her mood.
Hello everybody, I'm done with my meeting with Pranita, and Pranita is the trademark specialist, and literally she showed me a couple things I need to tweak and add, which it all really makes sense because you're supposed to be like writing this down as if you've never done it before. So some things I did was too generic, and you have to go into like the micro details and really explain everything. So I'm gonna tweak that right now because this weekend I'm going to Orlando, and on Monday I have jury duty to see if I get selected. So I just won't have a lot of time to really go back and edit and tweak these documents. So while I'm already in a working mood, I'm like, might as well just knock it all out at once. That way she's gonna look at the final copy now, and then we'll basically be done with the SOPs. We were talking about the loom videos, and we might not do one for these things just because it's a lot of micro steps and you can't really explain that all in a video when you already have the SOPs. So it just might be SOPs, which is the document of the steps. And then after this, we're gonna do the trademark prosecution defenses, and we're gonna talk about that later. I've been waiting to do those for like next week for real, because I know I need to go through like every defense for similar marks, which Attorney Randy explained to me, like how the US Patent and Trademark Office can send you a rejection, and basically it could be for different topics like confusingly similar marks or too generic. And so I'm focusing on confusingly similar, and there's like a DuPont test. I'm pronouncing it wrong because I haven't really looked at it yet, and it has so many factors, and basically I'm going to create a memo for all the factors for confusingly similar marks. I actually asked her if I can see all the factors for generic and just in general, so that I can just have that knowledge and review and read up on it even when I'm done with my internship. So yeah, that's what I'm about to be doing soon. But right now I'm about to go sit here and fix these SOPs while we already have the momentum and while we're already in the mood. So let's lock in.
Turn something to nothing, bro, I'm living proof. How can I lose when we the ooze? Still running around more, get ready to go, yeah. People probably think I show up, I ain't even keep it yet. Running up a
Okay everybody, I mainly finished my SOPs already, and I just can't believe it. Like, I'm gonna go back and just edit the grammar, but I added all the micro steps that I needed to do. And I just want to say this was a very tedious process. Like, I understand how it's good from the business perspective, but as a legal intern, I was almost about to take myself out. But it was actually fun because in the long run, I realized that like I really put this step by step. So now I know that I really know what I'm doing, and I know how to properly do a trademark application and a trademark search and things like that, because I wrote everything down on paper, and it's gonna help me in the future. So I'm actually grateful that I did it. Like, yes, it was tedious, but very grateful that I got to do this portion, because some of the assignments you do, you will like be like, why at first, and then you'll do it and you'll be like, wow, I learned a lot. And that's how the SOPs are for me. But I just gotta be a little bit dramatic at first, but I actually am looking back and I realized I really wrote down step by step on how to do a trademark application and step by step on how to do trademark searches. And I even gave an example of a specific client we had and how to do a search if somebody needs additional help. So it's actually kind of crazy because I'm like, wait, I really know how to do that job. And something I learned through trademarks is some firms outsource and reach out to somebody like an IP specialist who will do trademark searches for them, and then the attorney does trademark application, trademark prosecution part, because only a trademark attorney can be the one to contact and go back and forth with the US Patent and Trademark Office and no other staff. And that depends on the size of the firm. So if you're at a big firm, somebody's job at a big firm might be to do trademark searches only. If you're at a smaller firm, you know, they might outsource that and then you do the trademark prosecution, or even the other way around, just depends on the firm dynamic. So that's something I learned, and regardless, I'm happy and very thankful thankful to have trademark searches and trademark applications and now learning trademark prosecution on my skills list, because regardless of where I go, whether you're a big firm or a small firm, I know how to do things that maybe somebody else might not be able to do. Or say you're outsourcing and you just have an emergency and a client who really wants help and you really want to help that client. Now I know what to do in that moment and we can get the job done still. So very thankful to learn, because you never know where you end up, and I want to be somebody that can be used for everything. So doing those SOPs, I learned that really I know what I'm doing, and that, I'm very grateful to take that skill set with me wherever I go or wherever I stay. Next, we're going to do trademark prosecution, and my job is to do it on confusingly similar marks. There's other ways you can get a trademark denial, like genericness or too descriptive or confusingly similar word marks or trademark names or logo and other factors. And this is where it really gets legal. This is really where a trademark attorney becomes an attorney for real. And I say that because you have to get cases, you have to know how to legally argue, and you have to write and argue and appeal and go back and forth with the trademark examiner with like documents, like you're really doing an appeal. And then after that, if you guys don't get anywhere, you can even really appeal to the TTAB. That's when a panel of judges, I think 3 judges, look at your case and decide from all the facts of you going back and forth and all your appeals with the trademark examiner. So this is where it really gets legal. If you're looking for that little bit of litigation feel in this transactional world of, doing trademarks and doing trademark prosecution, this is where it gets a little bit litigation, except you're not really in court, but you're writing documents going back and forth. And I asked the supervising attorney Randy, if you could ever orally argue, and she was like, yeah, outside of the writing, she believes that you're able to do oral arguments if you really want to push for your client even more, even though the writing is typically sufficient enough. And you don't have to, and that's mainly optional. So that's very cool that like in this trademark space, you get a little bit of that litigation, feel a little bit of that back and forth appeals, and fighting for your client. So that's pretty cool. Right now, I'm about to do all of the trademark prosecution stuff. If I'm gonna be real, I already started, guys. Because I was stressing since I didn't know what to do, and when I don't know how to do something, I have to lock in. But now I figured it out, and really I'm going to go to all my arguments. There's 13 different denials for a confusingly similar mark, which I think is the most common outside of like generic and descriptiveness. And it's a lot of factors. It's called DuPont factors, and those DuPont factors, you look at the cases under each factor, and you really have to do legal research, legal analysis, and legal writing, almost as if you're 1L again and you're doing all those legal documents. Yeah, that's here. So I did a lot of feel like an attorney, and this is why I feel like you should go to an attorney, because if an attorney does your trademark search, to your trademark application, to your trademark analysis letter, to look at all the factors of what could make your mark confusingly similar to other people's, they already prepared their arguments as they started your work, versus just you coming to them and you getting a denial and now they have to fight for you and figure out angles, which that's still okay too. But when you work on something from beginning to finish, you have a stronger idea, you were in the process, you already seen the holes, you know what your strengths are, you could have worded things better to your strengths and try to avoid even getting a denial in the first place. But I see why, it's best to work on something from beginning to end, although a good trademark attorney can come in and try to help save the day regardless, but you give the attorney a better advantage when you let them start on your work from the beginning. Right now I'm going to work on my denial arguments of why, if we do get a denial, why it should be approved, and basically they're going to have this forever. I'm really creating a template of every single argument so that, if they do get a denial in the future, they can look at a template, have arguments ready to go, and make everybody's job easier. So I really feel good with all the work I do, because I feel like I contributed so much in a way as just a legal intern, to where I have SOPs that will be there forever for the next person, Loom videos that will be there for the next person, which is me showing somebody what to do. Yeah, I feel like, it feels good when you actually got to contribute to a firm and, you feel a part of the process. Sprinkle. But we're about to do those documents. I'm going to show you guys a little glimpse, not of my work, but of other works that you can find on the public server. So I'm going to show you guys something and show you what I'm doing so you can get an idea and you can appreciate the job of a trademark attorney and me as a trademark attorney in the future. And if you haven't, go watch my part 1, because that's when you see me doing the trademark process. And this video is just more of a mixture of everything. So yeah, see you guys when we start. Okay, you guys, so I'm currently in a classroom and I'm going to show you what it takes to be a trademark attorney, basically, and what it looks like when you go back and forth with the trademark examiner. So here is an example that I pulled from one of the websites because it's all public, and this is what you have to do. If you notice, you have to cite cases, you have to explain your factors, you have to say how they got it wrong, you have to use the law, and you have to break down cases. So this is what a trademark attorney is doing when you get a denial, and that one is only 10 pages. So what that tells me is that the trademark examiner probably only denied like the claim based on like 1 or 2 factors, but some of them could be like 20 pages, some of them could be 15 pages. It can really just range in length depending on how many denials you get for different factors, and that's what I did. I have basically been sitting here and going through each factor for at least confusingly similar marks and writing a whole analysis like you just seen for each factor so that the firm can have it for the future. Right now, I'm just keep refining it. I went to factor 1, made sure the grammar was good. I'm just gonna keep doing that throughout the week. So when I pick up the camera again, just know we will really be finishing this template. Tomorrow I have a meeting with the attorney. We're gonna see what new works I have. I'm gonna tell her where I'm at. And yeah, welcome to basically a week in the life of a trademark intellectual property intern. And then basically, guys, my internship is coming to an end. I really only have like 2 more weeks left. I just want to say thank you to the firm who really took a chance on me. When I look back, I learned so much and so many things. I used to be so scared to do internships, and now like internships to me is like something that I'm ready for, something that I am willing to do, and it just makes me stronger as a future attorney. So I'm very thankful for everything I know now, because knowledge is power, and it's always good to have knowledge in the field you want to go into. So I'm very thankful that I have knowledge with what I want to do. That way in the future I can go to an IP firm and already have some experience, or stay with this firm if I get an offer and have some experience, or just see where life takes me. And regardless, for when I have a firm one day, at least I know I started the process of learning what I really want to do. So thank you to the firm that I work at, and I will see you guys soon. Oh wait, yeah, I'm back. I'm also adding more arguments to my foundational arguments because I at least wanted to make sure that I had like everything down and different arguments, different cases, lots of cases for my template, and now I'm just going back to add more because I want to make sure that it's strong enough for the future and that, you know, it encompasses a lot of things. One thing you guys might not know about legal research and writing is that when you write, you basically have to have a case that backs up every single sentence that you do, and it has to be a different case. That way you can kind of show that it's strong in arguments and that many courts agree with that analysis, and it's not just one court, but it's majority of courts, it's every court. So that's why you need to go to an attorney in the future, an attorney to file and do your trademark application, because if you have to go back and forth with the examining office, and even just knowing the details of the application, it really takes a lawyer's skill and knowing how to argue and knowing what the U.S. Patent and Trademark Office wants and expects to see, and how to try to fight it to the best of your capabilities. Because legal writing is not just writing an essay, it's using the law and breaking down the elements and knowing what the elements is and fighting and using different cases to prove your point and knowing what the examiner is looking for. So yeah, I will see you guys soon. Yeah, now I really will see you guys soon. Thank you. Oh yeah. And there's Dominique. Hello everybody. So after working very, very hard and refining and doing my DuPont factors for the template, I have officially finished. And let me just say, in the beginning, it knocked the wind right out of me, but now I feel so accomplished, so happy that I really got that done. I would say that was one of the major projects that I really did, and I feel like I came out on top because when I submitted to the attorney, she only told me to add a major conclusion at the end, and I did that, and she said it looked great, and she took it. And yeah, that was very fun. It's always good to know when you do something properly. I feel like my whole internship, I was just testing myself, receiving assignments, clients, seeing what I can do and giving it my all. And when I just chose to sit there and think and reflect on what to do, and I would come up with the right answer, it kind of confirmed that I'm in the right space and I'm doing the right thing. But the benefit of a firm having a template is that, say they get a client that gets rejected on a confusingly similar mark, they can pull up my template, say they are rejected for number 3 and 4, they can look at arguments for 3 and 4, pull out sentences, pull legal research, and pull out cases that I found. So that's really going to help for every client going forward, and I'm really proud of myself for being able to do that. Also, after everything that you guys seen, I got 2 more blog posts to write, which I already finished. One was about the DuPont factors for the blog and educating clients, and then the other one was about how AI has recently been hallucinating and deleting files for major companies like Google and XYZ, and why AI should be treated like a tool and not the final product, because a lot of people are using AI as if it is complete, but AI does hallucinate, which means that sometimes AI lies to you, and it's not intentional, but AI is made to please you, and sometimes it makes things up. There's been reports of attorneys who used AI and it gave them fake cases, so it's very important that you know that AI is a tool, but it is not a supplement to real thinking, real learning, and real answers and real research. And the reason why we also talked about that is because in intellectual property, clients will come up to you and be like, I did a patent search or I did a trademark search of my own, and you'll see that they use AI, and AI will have fake citations sometimes or incorrect information about the trademark that they found that's similar to theirs. So it's just very important that you're not using AI as an answer, but as a tool, especially in intellectual property, because when you also feed AI that information, you're giving your confidential information to a third party. So say you have an invention, that's no longer just disclosed between you. Now you gave that to AI and somebody who owns that property. So you want to be very careful when it comes to AI and make sure that you seek an intellectual property attorney or somebody like me in a few months when I sit down, take the bar, and pass. Next, I also had lunch with attorney Randy and met her, you guys, in real life because my internship was remote, so it was good to meet her in person. We had a great time. We had a good lunch, and I really thank her for everything that she's done. I surprised her with the flowers, and yeah, too bad my camera broke when we sat down to eat, but I got this new camera, but we'll talk about that in later vlogs. Something else I did just to end my internship was 3 more reels that she wanted me to do, but I was focused on making sure I had the templates and things done because the reels would have been extra since I finished all my requirements. But to leave on a positive note, I did 3 more reels. I went out of my way and I finished because I want anytime anyone thinks about me, Legally Naya, to know that I go above and beyond, not just at work, but for my clients and in life, because that is very, very, very true. I wouldn't be sitting here doing YouTube today. I told everybody at the firm bye, from the paralegal to the legal assistant to the IP specialist, and I said thank you so much for everything you guys have taught me, and yeah, for welcoming me on this team. And then at the very, very end, me and attorney Randy actually went through a copyright application, and you guys, I am in love. Although the copyright system is a little bit outdated and not as caught up as the US Patent and Trademark Office, it was so fun seeing how creative works get published, get legally recognized, and I really love the process because it can be for photographers, songwriters, musicians, artists, sculptures, motion pictures, video, e-products, video courses. I love that because I am very deep in creativity, and honestly it's one of my biggest passions, and I really want to get into copyright very deeply and trademark because I want to put the power back in the hands of the artist and of the creator. So that's where I am at. But yeah, going through the copyright application really made my day, and it just put the cherry on top for my internship because now I really know a lot about trademark law. I know about copyright applications, what to do, and I found more information about knowing for each type of copyright, and it's really helpful. So I plan on just doing more research now that I'm done with my internship and staying updated with copyright law and trademark law. Oh wait, did I say I was done with my internship? Yes, you guys, today's August 13th. And I finished my internship about a week ago. I am officially done. I am officially a law school graduate. So now I'm just going to tell you guys my goals of what I'm looking for as I transition. Yes, I'm going to start, and I am preparing, and I've already prepared to start studying for the bar. But also, I am officially looking for an entertainment firm that has an intellectual property section to work for. So if you're an entertainment attorney, or if you know someone in entertainment, please send them my information. Please send them my YouTube, and know that I am seeking a job in the field. preferably in South Florida, Palm Beach, Broward, or Miami, or Orlando. I'm equally satisfied with moving to Orlando. So that is where I'm at, you guys. I want to open my wings, branch out, and work in entertainment, and hopefully I can land a job in entertainment after I take the bar. And that's an update with me. Now we have to get ready for the bar, and let me know if you guys want bar content and studying for the bar and how I prepared and how I'll be preparing. So make sure to like, comment, and subscribe. I am so thankful for this internship. I genuinely learned so much, from copyright to trademark to patents, and I'm thankful. Intellectual property is a beautiful field, and I plan on working in it even more in the future. I can't wait to have all of you guys as clients, and just know our time is coming in a couple months. Nice to meet you. My name is Legally Naya, and I'm going to be your future attorney for negotiations, contracts, entertainment, music deals, but also protecting your music, protecting your creativity, and making sure that you are the one winning. Legally Naya! Legally Naya! Get you an attorney who wants to see you win too.